This webinar, Foreigners Living or Investing in France and French Expatriates, What are the Pitfalls and How to Avoid Them, was organized by the Paris chapter of the European American Chamber of Commerce and recorded on December 17, 2020. The first speaker is Catherine Pruitt, Executive Director of the EACC chapter in Paris.
Thank you, Todd. We have about 50 participants here with us today who have registered, and it's great to see that we have so many people from France and the United States, and we have a lot of from your chapter, Todd, in Cincinnati. Today we're joined by a panel of complementary insight all around this subject. We're going to start off with Delphine Eskenzi, partner at Libre Avocat, who's going to cover marriage and how to anticipate with a marriage contract, tools to clarify, regularize the current situation, and divorce procedure strategies. Following that, we have Sophie Ducon-Monod, who is the founder of Ducon-Monod Notaries here in Paris, and she's going to talk about how to anticipate in matters of transfer by inheritance. And Stephanie Overil, partner at Arcwood Paris, will follow up and will cover various aspects of tax planning to include examples of national specificities and particularities of each system which do not export well. I'd like to remind you that after each section, our panelists are happy to take questions. So you may use, as Todd mentioned, the Q&R or Q&A function throughout the webinar, and they will be able to see these questions and will choose to answer them. So with this, I would like to leave the floor over to Delphine.
Thank you, Catherine. Thank you very much. So I'm going to speak about the issue that we have very often of matrimonial property regime and prenuptial agreements, and more specifically, how to ensure when you have either French nationals living in the United States or one French national living in the United States or the other way around, which are Americans living in France. How do you make sure that this issue of the matrimonial property regime, which is a French concept, is actually covered, and the other way around, how do you ensure that for instance, a French marriage contract will be recognized in the United States? And the key idea about these slides is that the issue of estate will be covered afterwards by Sophie. So I will be mostly focused about this issue of how to prevent a risk of divorce. I mean, if there is a risk of divorce, how do we make sure that the issue of division of assets is covered in a protective way for the person who actually has an interest to protect it? So I took an assumption, a nice story about Alexandre and Wendy, and you'll see on the slides that they're a happy couple. They've actually moved between France and the United States, and they both want to protect the assets. Wendy because she's the beneficiary of various trusts, and Alexandre because one day he would like to take over the family's business. So basically they are considering to get married, and they come to us. They don't know exactly where they're going to live in the future, whether they're going to live in France or in the United States. And they come to us and they say, what do we do? I mean, we want to get married, but we would like also to ensure some kind of protection. What's the best way to do it? So the first question is, should they do anything? Because it's true that one option is always not to do anything. Without further ado, I'll give you the answer, which is yes, they definitely should do something. Because if they don't do anything, the difficulty, and people don't always realize that, the difficulty is that there will be rules applicable to them, but it will not be the rules that they would have necessarily anticipated or chosen. Because, for instance, in France, when you don't have either a marriage contract or a prenuptial agreement, we apply the law of the place of habitual residence right after the marriage. And people sometimes don't realize that this place where they have lived not for so many years will actually bind them for the rest of their married life. So for this reason, we consider that it's actually very important to sign some kind of document when you are getting married. So once you say, okay, you should sign something, the next question is, what do you sign? And should you sign a document in France? Should you sign a document in the United States? Should you sign one document? Should you sign two documents? Actually, it's a question that we have very, very often. In the United States, it's very frequent to say we'll sign, for instance, a prenuptial agreement, and we'll have a mirror agreement in France, which would reflect the same terms as the prenuptial agreement. That idea is actually not a good idea, because from a French perspective, normally you should always have only one binding document at one time. And if you have a US prenuptial agreement and, for instance, also a French marriage contract, then we would have the issue of having to determine which document prevails, and it's always a potential room of litigation. So you have to actually choose the main country where you consider that it's likely that the spouses will live in the midterm or in the long term, and it's usually a case-by-case analysis. And once you have spoken with the spouses and you have determined the place where you think that it is likely that they're going to live in the long term, then you consider that this is in a way your main country, and you're going to prepare a legally binding document in accordance with the rules of this country. The idea here is that you have determined the country which will have the strongest connections or relationship with the spouses in the long term. But at the same time, you want to make sure that this document will still be recognized also either in France if you decide to do a prenuptial agreement, or in the United States if you decide to do a marriage contract. So how do you make sure that a French marriage contract is actually recognized in the United States? And the other way around, how do you make sure that a US prenuptial agreement is recognized in France? So I'm going to cover now mostly some of the formalities that are very important to keep in mind to ensure this recognition in both countries. When you do a no, not yet. When you do a French marriage contract, usually you use only one notaire, someone like Sophie Ducamp-Monod, and it is assumed in France that a notaire is someone who is independent and who is capable of advising both parties exactly the same way, and who has absolutely no conflict of interest advising the two parties at the same time. That concept is very French, and unfortunately is not necessarily very well recognized in the United States, where one of the most important requirements to ensure recognition of a marriage contract or a prenuptial agreement is this idea that each spouse has received independent advice. So for this reason, one of the first things, if you want to do a French marriage contract, because you've decided that France is the country which will have the closest connections in the long term, you make sure that each party receives independent advice, which means that either you have two notaires or you have one notaire and two lawyers. But in any event, you make sure that each party does receive independent advice. That's the first criteria, which is very, very important to keep in mind when you are working with a French marriage contract for which you want to ensure recognition in the United States. The second requirement is the financial disclosure. This is also something which is absolutely not French at all, because in France, it's very rare that families speak about finances before they get married, and we usually consider that it's a little bit taboo to ask someone, by the way, what is your family's wealth? Well, actually, in the United States, it's very important that there is some kind of financial disclosure when you sign a prenuptial agreement. So when you do a French marriage contract, again, if you have this objective of recognition in the United States at some point, you make sure that you attach a financial disclosure when you do the French marriage contract. And finally, you make sure that there is enough time for the parties to really consider the draft and that the document is not signed the last minute just before the wedding. That's very important. The second issue, or the second issue is the other way around. Let's assume that we've decided that the United States will have in the long term the closest connection with the couple. How do you make sure that your prenuptial agreement is actually recognized in France? Now, the first thing, and it's the sentence that I mentioned at the top of the slide, the first thing is that we have a new European regulation which is enforceable now in France. And it says that when one of the parties is actually habitually resident in France, you have to comply with the formal requirements which exist both in France and in the United States. And in France, normally marriage contracts must be signed before a notaire. What does it mean? It means that even if you're doing a prenuptial agreement governed by, let's say, New York law, and one of the parties is habitually resident in France, for validity in France, it is absolutely crucial for the agreement to be signed before a French notaire in the authentic form. So that's the first criteria to ensure recognition of a US prenup in France. The other criteria, and it goes to my last slide on that, also, is that you need to make sure that the contents can be understood by the French context. French concept. Sorry, it's the next slide, not the one before. So basically, when you do a prenuptial agreement, usually the rules are not very clear about what relates to the division of assets and what relates, for instance, to the issue of spousal support. So you need to make sure that the concepts are very clear from a French perspective, and it's usually very useful to have your US prenuptial agreement reviewed by a French lawyer or by a notaire to make sure that the concepts could be understood in France. Now, once we have met, I will say, those formal requirements, what do you put in the document? There is a very important difference between a French marriage contract and a US prenuptial agreement. The first important difference is that in France, you usually only include rules relating to the division of assets in the event of death or divorce. Whereas usually in the United States, you try to anticipate all of the financial consequences of the divorce, including a potential limitation or waiver of the spouse's right to the estate in the event of death. And you also try to anticipate the amount of spousal support. So you'll see that for this reason, the scope of a US prenuptial agreement is much, much wider than the scope of a French marriage contract. And this could be also a reason for choosing one document rather than another one. Now, what is certain is that if you include provisions relating to children, it will not be recognized or enforceable in France. And if you include provisions relating to spousal support or maintenance obligations, it is potentially possible, but it will be reviewed with strict scrutiny if the issue is ever litigated before the French courts. You can also include a choice of jurisdiction and choice of law provision, but it is not certain that such provision will be recognized, for instance, in the United States, if the parties are no longer living in the United States at the time and you've elected US courts. So I guess that covers most of the things that I wanted to say about this issue of matrimonial property regime and marriage contract and prenuptial agreements. One last slide, but I'm not going to comment too much on it. Just a few things to keep in mind, just in case you've done this magnificent document, but the parties still decide to divorce. Well, when you're trying to figure out which country will be best in the event of divorce, these are, and I'm not going to comment on it, it's just for you to think about. I have put a few factors that you can consider when you're trying to consider whether you should do your divorce in France or in the United States. That's it for me.
To invite anyone to ask any questions. I don't know if some things have come in the Q&A, but a question that we had from a participant that came in before would be about a U.S. prenuptial contract and how to make it work in France.
So yes, as I mentioned earlier, the most important thing when you do a US prenup and you want to make sure it will work in France is really to review the concepts, because they're very different in the way they're presented, and very often US lawyers will draft those documents without taking in necessarily in consideration the fact that they're making references to concepts which will not be understood if they're being read by people who are outside their jurisdiction. So you want to make sure that the document, while it is most of the time lawful in France, it's not so much about what is said than how it is said. Because you want to make sure that the concepts could be understood if they're actually reviewed by a French judge.
Great. Okay. I'm sure we'll have more questions, but right now maybe we can move to Sophie to start off, and then we can come back with questions from the participants. Thank you, Sophie.
So before presenting you conflict of laws for transborder transfer by inheritance, I want to insist on the importance for US advisor and French notary to work together. In order to illustrate the idea, let's imagine a US, French, and British organizing a party. The disaster scenario would put the French in the organization and communication, the British in charge of the cooking, and the American in charge of the respect of the protocol. This scenario applies when each one works without wondering what is going on both sides of the Atlantic. On the virtuous scenario, by contrast, would put the American, Catherine, can you? Yes, good. Would put the American in charge of the communication and organization. And by the way, thank you, Catherine and Todd. And the French in the cooking and the British in the respect of the protocol. This plan works each time when transborder advisors work hand in hand. So the European Union has ratified a regulation dated on 2012 and came into force in 2015. And this regulation gives the same private international rules among all European states, all except United Kingdom. Brexit does not change anything, Ireland and Denmark. They give the same rule of conflict of laws. First, they define under Article 3 what is succession. It determines the beneficiaries of an estate after death, their respective shares, their capacity to inherit, the transfer of assets after death, the liabilities of debts, the powers of heirs and executors, the right and obligation of legatees, and the reserved shares. It does not concern either tax issues or the creation, execution, or trust. The difficulties to settle transborder transfer by inheritance result from a radically opposed conception for transfer of inheritance. Under common law, US law, when one person dies, his or her estate is remitted to an administrator or trustee who is in charge to pay debts and inheritance tax. On a tax point of view, the rate of taxation is based on the amount of the whole estate, no matter who inherits. Under continental law, French law, when one person dies, his or her heirs succeed immediately, there is absolutely no need to appoint any administrator or a trustee to pay debts. Once heirs have accepted the inheritance, they are personally liable on the personal estate and to pay the deceased debts. On a tax point of view, the rate of taxation depends on the kinship with the deceased. A child is much less imposed than a third party. So now let's see the different conflict of laws. I've always been told that under US law, the law applicable is the law of the last residence, except for real estate, where status law applies. Two laws may be applicable. Under the European Union regulation, there is only one law for the worldwide assets. And this law is the law applicable of the deceased habitual last residence at the time of death and is to apply to the whole succession, real estate and movable. So let's take an example. A US citizen resides in France where he dies, and he used to own an apartment in New York. French law in this case applies, and including for the New York apartment. I am afraid that the New York jurisdiction will apply the European rule. The second rule is called the renvoi. It provides that if the deceased has not chosen any law in his will to govern the transfer of his inheritance, the member state, that is France, should accept the law appointed by the third state, that is the United States, if the latter appoints the competence of the member state, that is France. Another example, let's suppose that a French citizen lives in New York where he dies, and he used to own an apartment in Paris. The New York law will appoint the French law for the real estate for the apartment in Paris. According to the European Union regulation, French will accept the designation made by the New York law. The last rule under the European Union regulation is that a person may choose his or her national law to govern his transfer by inheritance if he appoints in his will this law. This law will be applicable for the whole estate, real estate, and movable. In our former example, in the American who lives in France, owning an apartment in New York, may appoint the American to govern his inheritance. In this case, the European regulation and France will recognize the American law applicable everywhere. So it seems that if a testator may choose under a New York law the law applicable to his or her estate, this choice cannot circumvent public policy rules as the elective shares in favor of the surviving spouse. In order to facilitate the execution of a will among borders, the American lawyer and the French notary must work together. For instance, a French court will never deliver a grant of probate because it does not exist under French law, because it doesn't know what it is, and because for French jurisdiction it is useless. So the solution would be that in each country, a will is made, one in relation with the other, regarding the assets located in both countries. This leads to illustrate two other questions. So, shall an American citizen create a trust to govern transfer of assets located in France? Trusts are often created in US to avoid the federal estate tax. Stephanie will explain you afterwards how French tax administration cooks the trust in France. Now, suppose an American appoints the American law to govern his estate by the transfer of inheritance of his estate. And then, according to the American law, he creates a trust. How this trust will be received? Well, trust and civil law do not exist in France. And I remind you that the reserved heirs have all the powers the very day of the death of the deceased, of the testator. So in presence of reserved heirs, child, spouse, Oh, I think yes. Yes. In case there are reserved heirs, the reserved heirs will oppose their powers to the trustee. So the trustee will not be able to oppose his powers under the trust deed. And moreover, if there are real estate located within the trust, the land register will not be able to publish the trust in land registry because it doesn't know what is legal property and equitable interest. If the trustee appears in land registry, there is a strong tax risk. And on reverse, if the beneficiaries appear in land registry, they will have much more powers than those conferred in the trust deed. So to summarize, on a civil point of view, a trust will work only if there is no French real estate located in the trust and there is no reserved heirs. Last questions. Shall an American citizen fear the reserved heirs? According to French law, a testator cannot transfer his or her estate as he wishes if a child or a spouse survives him. Indeed, in France, the rule provides that a child or children, or in absence of children, the surviving spouse must inherit a fixed portion fixed by law. In those cases, testator is not free to dispose all his estate in favor of third parties. So what happened if the American appoints the American law to govern the transfer of his inheritance? The Supreme Court said in 3 decisions dated on 2017 that the internal reserve rights were not breach of public policy. However, the French court decision will not probably maintain in the future because it is actually discussed in front of Parliament a law to introduce a mechanism organizing a compensation when the succession is not governed by French law. 2 conditions must be observed. The first one, the deceased or one of his children is a national of a member state or reside within the European Union. And second condition, the law applicable ignores any mechanism equivalent to the reserve portion. So under a pure American context, testator, children, and surviving spouse all are American, I think the reserve portion will not be a compulsory rule. But you have to be more cautious each time there are French heirs or in a case where a French citizen change of citizenship to adopt the American one, make a will and die. In those cases, please contact the French notary, the French advisor to find other tools like creating an SCI or the insurance contract. But in the insurance contract, we have to be careful about the tax regime. But I guess my time is over and I let Stephanie explain those points.
Thank you very much, Sophia. We had a question that came in previously, maybe just one question to you before we move on to Stephanie. And the question was, how does a Pax union transfer from France to the United States? This was something that came in from a participant.
You may also want to explain what PAX is. It's an acronym, PACS.
A PAX.
Yes.
I mean, there are even with a partner, someone who is is not married, but with as only not a partnership, a PAX. There's still the problem of a reserve portion, and we have still to think about making a will with both. I mean, the U.S. advisor and the French advisor. We have still to be careful on all these questions.
Yes. Delphine, would you have something to add to that?
Yes, sure. I mean, about the recognition sorry, I have some issue. Yeah.
Yeah, the recognition of a PAX in the United States.
The recognition of a PAX in the United States, yes. I mean, I've had this issue before, and normally it is actually recognized as the equivalent of a partnership or the equivalent in most US states. So it's not, I mean, I'm not sure what the issues are in this respect for recognition. But the issue, I mean, the only issue I've had with that, and which relates to divorce, since that's what I was talking about, is that the only thing is that in France, a pax is terminated without the involvement of a judge, which just by solely the parties just decide to terminate a pact by sending usually a letter. And that's something where there may be sometimes issue of recognition. I've had that not with the United States, but with Australia recently.
And I have to add in case of inheritance, if you have made a contract of pax, the partner do not inherit automatically, which means that if you want your partner to inherit, you have to provide it in a will.
Very good, thank you. So without further ado, we'll move on to Stephanie.
Okay, I will discuss tax matters now. Actually, especially for US citizens, and we have a lot of cases experience for American people living in France, relocating to France. And during that short presentation, I will probably raise a few US points. And obviously, I'm not giving any US tax advice, but it's just to talk about experience of the benefits or the problems with certain structures between the US and France. So regarding the relocation to France, the key tax issues that you have to keep in mind, first is the test for tax residence, because when American people would want to spend some time in France, the key question is how and when they will become taxpayers in France. And as you may know, France does not tax French citizens, but France would tax French tax residents, even if they are non-French citizens. So the key tests for tax residents are very different from the US test for tax residents, and it's really several kind of tests that need to be considered depending on the duration of the stay in France and the intention of the family. For certain Americans who just want to spend a few months in France but keep strong ties with the US and continue to travel back and forth between France and the US, they would probably not become French tax residents and then not French taxpayers. But if on the contrary, they decide to move with the family and the kids would go to school in France, if the parents would work in France, for sure at some point they will become French tax residents. And being French tax resident have a lot of tax consequences, because it means that you become taxable for income and capital gain tax purposes on your worldwide incomes and gains, but also for estate tax or inheritance tax or gift tax. Normally, you become also subject to French tax on your worldwide assets. So it's a big deal. But there are, of course, a few measures that impact, that reduce the taxation, especially for US people, and I will come back to that later. But more generally, in order to attract foreigners on the French territory, we have had a tax regime called the impatriate tax regime, which is the contrary of the expatriate, so people coming to France for income tax purposes. This is mainly for people who relocate to France to work as employees or corporate officers. You may know that in France we have a wealth tax, impôt sur la fortune, that for now applies only on real estate. And we also have a separate impatriate regime for wealth tax purposes, meaning that when you become French tax resident and you have not been tax resident for the past 5 years, you can be exempt, or you are actually exempt of wealth tax on your non-French assets. It means that for the first 5 years, you are kind of treated as if you would be a non-resident of France. You are subject to wealth tax only on your French real estate. When you or your clients consider moving to France, there is another thing that is very important to keep in mind, is that we have an exit tax in France. An exit tax is a tax on unrealized gains on investment assets, basically. I really summarize that. So when a person has been a French tax resident during at least 6 years out of the last 10 years, and this person leaves France and ceases to be a French tax resident, then he's charged an exit tax on unrealized capital gains. So it's very important to have that in mind in the context of a global strategy of relocating to France. We have that 5 years exemption of wealth tax. We have that impatriate tax regime for income tax. But so really, the key period is 6 years, because after 6 years, if the person decides to stay in France and then subsequently would leave France, he might be or she might be caught by the exit tax. That's very important. And I'll come back on the trust reporting, and Sophie announced that I will speak about trust, and I will for sure later on, but it's really an important topic to be kept in mind. And really in the context of relocation, this slide is important to have the main topics. So I said that there are a few specific issues for US citizens who become French tax residents, and that's on the next slide. Especially for US people who are investors or who have incomes and gain from portfolios of assets, securities, bonds, private equity. And this regime is very specific to the US-France double tax treaty. Under that specific provision, it says that US citizens, because they continue as US citizens to be subject to US federal tax wherever they live in the world, if they become French tax residents, basically they will not be subject to French tax on their incomes and gains on investment of US source. So you have here a kind of a picture where you have the family living in France, US citizen, and they have in US investment that meet a certain number of criteria in the double tax treaty between France and the US. These incomes and gains on eligible financial investments would need to be reported on the French tax return of the taxpayer, but they would enjoy a tax credit that equals the French tax. At the end of the day, it means that there is no tax. You know that you may know, I don't know, that investment income at the moment are subject to a flat tax of 30% plus potentially a 4% additional tax. The whole French tax would be totally eliminated on these incomes and gains of US source. On the US side, under the current regime, these incomes and gains generally are subject to the 20% for long-term gains and qualified dividends, and for the rest, ordinary income. So in that scenario, so the first one, US source investment incomes, the very good news is that no French tax would be due. The tax would be the federal tax of 20%. And then what happens with the state tax? If you or your client come from a state that is a high tax state in the US, like let's say California or New York. If you relocate to France, you become a French tax resident. It means that you are no longer you are a US citizen, but you are no longer a tax resident in the state you come from. So California, New York. So normally, these states, they don't have the right to tax your incomes and gains any longer. So if you used to be subject to, let's say, a 13% tax in those states, these taxes would simply disappear. And on the contrary, you will not be subject to any French tax. So in certain scenario, for certain kind of taxpayers, becoming French tax residents even saves tax, believe me or not, but of course there are a lot of other topics. So just to finish on that slide, of course, this specific provision applies only on US source incomes and gains and not on non-US investments. It can be French investments, but it can be Brazil, it can be Canada. And in that case, the French tax continues to be due, knowing that the French tax would be credited under certain limits against the US tax, the US federal tax. So on the trust matters. Okay, so Sophie explained that I will talk about trust, of course. So all of our American clients who relocate to France or those who are still in the US but invest in France have trust. I mean, those wealthy people. So generally, for income and capital gain tax purposes, under French domestic rules, those trusts are not disregarded entity. It's very complex rules, but in the French-US context, the double tax treaty between France and the US tax treatment is generally recognized in France in a way that revocable trusts or grantor trusts, where the grantor or the settlor continues to pay the French income and capital gain tax. For French tax purposes, they are very good. The position is to say that will follow that flow-through treatment. I mean, the disregarded treatment that is retained in the US. For the other taxes, the wealth tax and estate tax, the bad news is that trusts are disregarded for tax purposes in France. I mean, by law, the settlor or the grantor is deemed to own the trust assets. And that's why if those trust assets are French real estate, or real estate, wealth tax would be applicable as if the trust would not exist. For estate tax, because the settlor or the grantor is deemed to own the trust assets, means that upon death of the settlor or death of the grantor, then if he or she is a French tax resident, the trust assets would be subject to French estate tax. That could really defeat US estate planning strategies, because we know that in the US you would use grantor trusts that would, in certain cases, be deemed already, I mean, the assets would already be deemed transmitted to the beneficiaries, often the children. And for French tax purposes, that treatment would not be recognized, which is really a situation where trusts do not export well at all in France. So anyway, there are a few pre-immigration planning that need to be considered through gifts, through the use of a spousal exemption, because in France we have an exemption between spouse, exemption of inheritance or estate tax. So it is absolutely possible to elect for American people, as Sophie explained, to elect for the law of the US laws for the succession planning, in a way, for example, to provide that the spouse would be the only beneficiary upon death of the first spouse to die. That's just, of course, that's a choice of law that would enable to transfer all the estate to the spouse. And thanks to that, and because we have a spousal exemption, that might be a good idea to avoid the French tax upon death of the first. And we have a set of reporting of the trust in order to make sure that the French tax is due and paid when appropriate. So that was the first example of strategies that don't export well in France. And on the contrary, the last example is a French strategy which do not export well in the US, which is the split of ownership between usufruit and nue propriété. It is the usufruit is a life interest, and the nue propriété is the actual ownership. And we use that very often in France, notably in the context of a gift, in order to mitigate gift tax, in the situation where the parents would transfer an asset to their children. They would retain the usufruit, so they would retain the life interest, and they would give the propriété, the nue propriété. Because of that strategy, the taxable basis for gift tax would be reduced, because the parents would keep and retain the life interest. So the gift tax would be reduced, and upon death of the life interest owner, so the usufructor, then no French additional tax would be due. That's very good. That's very well recognized in France, but not necessarily in the US, where upon death of the usufruct owner, there might be a value, the value of the usufruct that would be subject to US estate tax. So generally, this kind of strategy can be used between France and the US only and mainly when the estate is below the threshold of exemption of estate tax that is currently around 11 million. When it's above 11 million, then the usufruct would belong to the estate, the taxable estate in the US, and there would be no tax credit because no tax in France. So that's clearly the kind of strategies that you need to consider twice before putting in place between the US and France. And that's it. And that's it. I was long.
A very concrete question that came in. It's, I own a home in France and have invested in 2 French businesses. I plan to apply for a resident visa shortly and would like to know have information on resident visa tax implications.
Oh, there's no direct link between visa and the tax residence. Of course, getting a long-term visa, no, it really depends on the kind of visa, because 12 months visa is a long-term visa, but it's really a visa you can't work. But there are other kinds of visa, like 4 years visa, that show that you intend to spend more time in France. It doesn't automatically mean that you become a French tax resident. For sure, the tests for tax residents are disconnected from the test for the visa. I don't know, it answers the question, right?
Yes, I think so. So I think, Todd, that we had another one on the Fisher question. What was that, Todd? Can you jump in?
Sure. The question that came in from Ryan Fisher, can you provide insight into pursuing dual citizenship? Are there long-term benefits for a U.S. citizen in gaining French citizenship related to all of these issues, succession planning, taxes, real estate, and so forth? And just to hop in, and I'm obviously not an attorney, but from my experience as a U.S. diplomat, I can tell you from the U.S. side, the U.S. does not recognize dual citizenship. If you're a U.S. citizen, you are subject to U.S. law in all federal matters. So, but I don't know how that works from the French side.
I don't see clear benefit, at least tax benefit, of becoming dual citizen. I mean, to become French citizen. There's no benefit. There's no problem as such. The only thing I see is a very specific provision in the treaty between France and the US for estate tax purposes that say that if you settle down in France, kind of temporarily for the first 5 years, and while you intended to keep US domicile, and you die in France, then you are not subject to French estate tax during these first 5 years. Only if you are only a US citizen. And from experience, that's a question I often have, and that's the only answer I can provide. I hope I have been clear, otherwise don't hesitate to send me an email afterwards. But frankly, there's no real problem, but no real benefit. The real problem is that 5-year period for estate tax. For the rest, no real problem. The main benefit, maybe it's not a tax benefit, would be an ability to travel between the US and France very easily. And we know that during these periods of COVID and travel restriction, it's precious to be able to travel easily between the two countries. So that could be a benefit. It's more flexibility in travel.
But yeah, tax obligations are generally based on residence, not citizenship.
Yep, absolutely.
So I have one question that we're getting to the end, and I spoke with some colleagues, and a question we had was, in each of your respective domains, when you're speaking about foreigners living in France and French expatriates, what is the thing that could have been avoided by something simple, where you get a client and you say, we're having to deal with this, and you could have, there was something that was perhaps painless that could have been taken care of, so that it might be a little piece of advice of something that doesn't take a lot of money or doesn't take a lot of time, but can say to make a situation much better financially or otherwise later. Would anyone have an idea?
Yes. Now, for example, when you invest in real estate, you are US or not US, you are everywhere. You invest in French real estate for certain money, and you have just bought the property directly. It's a pity that you should have considered an SEI or any kind of structure to hold the assets, and take a bank loan because the mortgages are very low at the moment in France. That would mitigate your wealth tax. That would also be very beneficial in terms of estate tax if you are, let's say, in the US as a US resident or domiciled. It could be very beneficial for both taxes, which are very high tax in France.
For me,
another idea is to make a will to prepare in case of death if the U.S. resident plan to come to France even for a short time, to think about making a will. But in general, it is the American culture to prepare a will. So they can see a French advisor, and again, I will not work myself alone. I will work with their U.S. advisor.
Mhm.
My one piece of advice is, well, kind of what I said during my presentation, which is if you think that there's a chance that your couple may fall apart at some point, it's always better to consider the issue of doing something about protecting you in the event of divorce before it happens than after. But I guess it's obvious, and it's a piece of advice you can have it whether you're American or even just French.
And when you say protect concretely, what would be the top?
Well, I mean, you know, we very often we see clients who don't, I mean, the typical example I see would be, for instance, French, the other way around, but French women following her husband to the United States or anywhere else, but let's say in the United States, and they're both French, they got married in France, but they never lived in France before they got married, and they immediately moved to the United States, and they don't necessarily move to a state in the United States which has a community regime, and she always thought that it was the French regime of community which would apply because they're both French. And then you tell her, well, actually, it's not the French community because you've never lived in France. And I don't care that you're two French nationals and you got married in France. If you've never lived in France, that's not French law. And you tell them that once they're getting a divorce and there is nothing else to do about this. So that's one of the common mistakes that I see, that people don't realize that the law applicable to your matrimonial property regime is not necessarily the law of your nationality, of your joint nationality.
Thank you very much. I think this is about the time that we have. Thanks to all of you so much. This concludes our webinar. And thanks for sharing your experience and to the questions from participants. Thank you also to our friends in Cincinnati and the United States for co-hosting this webinar with us.